Started. Welcome to today's webinar, Memo to Lawyers. You don't have to write like lawyers. My name is Alexandra Stevens, and I'm the Associate Director of Alumni Career Engagement here at the Hyatt Career Center at Brandeis. And I'm so excited to be joined by our presenter, Rick Horowitz, Brandeis class of 1970. He is the founder and wordsmith-in-chief of Prime Prose, offering writing, editing, and messaging services to institutions and organizations across the country. He's a graduate of both Brandeis and the N.Y.U School of Law. He had worked for a Washington law firm specializing in communications law and as a legislative assistant to a member of the congressional leadership. He went on to become a nationally syndicated columnist, winning 2 national headliner awards, and a commentator for Milwaukee Public Television, where he received 8 Regional Emmy Award nominations and 2 actual statuettes. So cool.
Very cool.
His latest project, and what brings us all here today, is trying to get lawyers to write more like, well, humans, at least some of the time. So, Rick, welcome to you. Welcome to the Brandeis alumni community on the line today. We're very excited to have you.
I'm excited to be here. Thanks, Alexander. And good day to everybody. Good afternoon to those of you on the East Coast, and good morning to the rest of you. Glad to be here. Thank you to the Hyatt Career Center for inviting me in. Thanks to my fellow Brandesian, Bruce Single, for first raising the suggestion with the Hyatt Career Center, and thanks particularly to Alexandra for hosting and fielding your comments and your questions. As it happens, I was in Boston just 2 weeks ago. There was some kind of baseball tournament going on there, as I recall, something like that. Actually, I was not there for the World Series. I was there, though, on Beacon Street at the Boston Bar Association in what turns out to be the Louis Brandeis room at the Boston Bar, doing a workshop for the bar there. That was excellent, being in the Louis Brandeis room, and also a little bit strange because when I graduated from Brandeis, and before I graduated, I had no idea I was going to go into law, no idea I was going to go to law school even. I know they had pre-med there, they had pre-dental, I think. I'm not sure they even had pre-law at the time I was there. I was technically, I think, pre-snack bar in my learning, and graduated with no idea that I was going to law school, but by the following autumn I had applied, had been accepted to N.Y.U, went there, and as Alexandra said, started doing, practicing law, ultimately left it, started writing, started teaching writing, and then ultimately circled back to teaching about legal writing and helping people with their legal writing. The workshops I do, the full-day workshops, tend to come in under the title More Effective Writing Makes More Effective Lawyers. I've been doing those monthly now for a little about 1.5 years for the DC Bar, and now beginning to offer them elsewhere. Boston, as you heard, Louisville, Memphis, Portland, the one in Oregon, not the one in Maine. Although if any of you are from Maine and want to invite me up, that's great too. The more I did the workshops, the more I noticed and the more I heard from the attendees themselves, the lawyers themselves, 2 propositions. One was that as lawyers, you tend to, or we tend to, I'll say you because you're currently in it, I have been. As lawyers, you tend to know your subjects very well. On the other hand, as lawyers, you're not always able to communicate the things you know as well as effectively as you might like, in the various circumstances you find yourself in, to the various audiences you find yourself writing to, for the various purposes you're trying to achieve. My job in my full-day workshops, and also in the 90 minutes we've got here together, is to try to help close that gap. And to do that, and because it's Brandeis, it's worth the extra time to do it, we've got a reimagined, redesigned mini version of my webinar. And this one, in addition to being called, as you saw, this, Memo to Lawyers, You Don't Have to Write Like Lawyers, has its own subtitle now, A Few Legal Writing Habits Worth Breaking from Time to Time. We'll be coming at the topic from some entirely different angles from what I do typically in my full-day session. I want to examine, I thought it would be useful to examine the lawyer's mindset when it comes to writing, and hold some of lawyers' assumptions and default settings up to the light for some further examination. See if they're really the best way to go in all circumstances, or whether there might be options you haven't considered for one reason or another. And some of those reasons, I should say, I mean, some of those reasons are perfectly good ones. Some of the habits you have as lawyer writers are actually rules that courts insist on, or they're office traditions enforced by your bosses. And I'm not advocating revolution, despite having gone to Brandeis when I went to Brandeis. Some of these are rules that need to be followed, and I say follow them. Some of them are perfectly good rules. Others, maybe not so much. And so my argument for you today is to test those out, see if there are some spaces in the margins, some more flexibility, more approaches than you think you have available to you. Okay, so that's what we're going to do with your help, with your questions, with your feedback. And let's start, if we can, with poll question 1, followed pretty immediately by poll question 2, so I can get an idea of who's in the room and try to find the sweet spot in terms of what kinds of things we talk about. So if you'll take a moment and just answer this first question, and then we'll move on to the second question. Let's give it a moment.
So our first question here, how long have you been practicing law? 0 to 5 years, 5 to 10, 10 to 20, or more than 20 years? And then we'll go ahead and share the results and see who you're on the call with.
And if you happen to be right on the dot of 5 years, feel free to go in either direction on your answer. We're flexible here.
Okay, this looks like a very participatory group. I like this.
Good, 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 good.
So almost everyone's voted, so I'll go ahead and share the results.
Okay, let's see what we've got.
So Rick, it looks like more than half of our listeners have been practicing for more than 20 years.
Okay, so we can work on long-held assumptions. That'll be good.
Yes.
That'd be good. Should we try the second question now and go there? See, again, just a little bit more of what you do for a living and how you do it and what kind of writing you're likely to be doing. Litigation, regulation, transactional, or what we're calling other.
And if you want to type in your other into the chat box, I can share that as well.
Oh, good, 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 good. Wasn't sure about that.
So give you a couple more seconds to weigh in or to type in your others. And then we will go ahead and share those results again.
You can feel the tension mounting, can't you?
So one person is a mediator. Special education, advocating for parents, trying to avoid litigation, another arbitrator and mediator.
Oh, good. Okay.
Okay.
All right.
So it looks like
spread.
No regulators here, but focused primarily on litigation, transactional.
Okay, that's a good spread. That's a good spread. Why don't we move on? I want to call this next part when lawyers write, is there a problem? And let me have you take a moment and take a look at this excerpt from Wydick, Plain English for Lawyers. See if it sounds familiar to you. Using 8 words to say what could be said in 2. Redundant, verbose, phrase within clause within clause. You're speed readers, right? You went to Brandeis. The result is a writing style, he says here, that according to one critic, has 4 outstanding characteristics. It is wordy, unclear, pompous, and dull. How do you hit that perfecta and enjoy it? It's hard to do, and it's harder even for the people who are reading your stuff. And then beyond wordy, unclear, pompous, and dull, there is the possibility of incomprehensible. I'm not sure whether every legal workshop and seminar requires a learned hand quote, but I figured, why take a chance? So here's our learned hand quote for the day, and we'll move on from there. But look at that. The language of the law must not be foreign to the ears of those who are to obey it. Sometimes it is, more often than it ought to be, it is. And based on the questionnaires I get from the workshops I do, more often than people even want it to be, it is foreign to the ears of those who are to obey it. And so I'd like to talk about that with you a little bit. Some of it, I'm convinced, is sort of lawyer's mindset, writing you learned when you were in law school, maybe I would argue even overlearned when you were in law school, or has been drilled into you since by some senior person who has a particular way of doing things and thinks you ought to or need to as well. My argument to you today is that you've got more options than you think you do, that in many situations you have other choices, that there are other approaches you can consider, that there are other strategies and tips you can employ, things you can try depending on how you read those situations. In fact, if you come away with only one phrase, one tip, I expect there'll be more than that. That's my plan. But if you can come away with only one, it would be this. It would be situational writing. Okay, that's what we're sort of talking about, how you read that situation. What I'd like you to do, just take a second, think of all the kinds of legal documents you write. And I'm talking in that way, not just about official filings, but about all the other things you have to communicate in some written form, whether that's a memo, whether that's correspondence to a client, whether it's a quick email, whether it's a Twitter blast of some sort. Think of all those. Then think of all the types of people who will be reading them. Some will be experts, some will not. Some will be clients, some will be peers, some will be senior partners, some will be novices, okay? And then what I do in my classes, in my workshops, I ask people to give me a list of verbs, just all the things you want your writing to do at various points. And that can be everything from, and you can think of them yourself, from inform to explain to request to reassure to persuade to threaten to harass to mobilize to inspire. Every one of those is something you may find yourself wanting to accomplish by your writing at some point or other. So here's my question. I can't do all the permutations and combinations in my head of all those kinds of legal documents, of all the kinds of people who will be reading them, and of all the verbs, of all the things you're trying to accomplish by writing them. But let me ask you this. Why would you possibly think you should write each of those in exactly the same way? With the same amount of detail, with the same level of technical language, with the same use of acronyms or shortcuts, or not? With the same tone? Why would you think you should be doing that? I don't think you should. That's going to be my argument today. I think situational writing ought to be the newest and one of the most effective tools in your writer's toolbox. And I say that regardless of what level of experience you have or how long you've been at it. That's where we're going to focus on the kinds of things that go into the writer's mindset that might come up with different answers if you think of the situation you're in different ways. Let's pause for a second and go to poll question number 3. Just get you thinking in a writer's mindset. I realize I've only given you 6 choices and other here, but these are ones I have found are often things that lawyer writers describe as the most difficult part of the writing process for them. And so I want to see where you guys stand, where you folks are, and what's difficult for you. I'll pause a minute while you fill these out.
Right, so polls up on your screen now. What is the most difficult part of the legal writing process? Is it deciding what to include and what to leave out? Organizing your research, facing the blank screen for that very first sentence can be awfully daunting. Making the argument flow, finding the right tone, catching your errors, or if it's something else, let us know in the chat.
Chat box.
I'll give you a couple more seconds to weigh in there. It'll give us a good place to start.
Okay.
All right, so it's looking like I'm going to go ahead and close the poll.
Sure.
All over the place.
Good.
The vast majority of deciding on what to include and what to leave out.
Okay.
But everyone selected every other one too.
We're up at upwards of 20. Yeah. Okay, well, that's good to know.
Well for that.
Okay, that's good. We'll be talking about several of those things during the day. I like to try to keep workshops and the whole concept of writing as simple as I can for people because they can find it daunting. Even experienced lawyers can find it daunting based on the questionnaires I get before my full day sessions. I try to keep it simple by suggesting that most writing, legal writing included, can be broken down into answering 4 questions. What's in? What's out? Where do I put it? How do I say it? I will tell you that over the last couple of months, I have started thinking that 4 isn't quite enough, that there's sort of 4.5 or maybe 5. And so I've added this one, and given that several of you are talking about tone, the how do I say it and how does it come across? What's the person on the other side of the table going to hear, going to read when you write what you write? And I think both of those, all 5 of those, are important. Let me try to suggest to you that answering those questions, the best way to start answering those questions is to consider two other key factors. And let me introduce them to you, not so much explain, but introduce them to you in both cases with non-lawyer stories. But I think they'll be applicable, and I think you'll catch the connection pretty easily. First one is a Michelangelo quote. This is the only Michelangelo quote we'll have in the session, so pay whatever attention you want. The quote is, "The more the marble wastes, the more the statue grows." The more the marble wastes, the more the statue grows. And I have always had that story, that quote, attached in my mind to a story that may be apocryphal. I don't know that it ever happened, but I've read it in several places, where someone goes up to a sculptor. Let's say she's sculpting an eagle, and the person asks the sculptor, "How do you sculpt an eagle?" And the sculptor says, "It's simple. I carve away everything that's not eagle." Okay, so you have to decide every time out, particularly if you're trying to figure out what's in and what's out, where you put it, what can be left aside. You have to decide on your eagle every time out. What's your eagle? It's your goal. Call it your goal, call it your mission, call it your purpose. What's the thing you're trying to accomplish? And we're back to those verbs we were talking about a moment ago. But you have to know what the goal is. You can't get there unless you know where you're headed. I can throw a Lewis Carroll quote at you from Alice in Wonderland to much the same point. If you don't know where you're going, then any route will get you there, or no route will get you there well. So you have to know where you're going. Goal is the first of the key factors to answer those 5 questions. What's the second one? Okay. Here's another story for you. You were out on Saturday night, last Saturday night. You had a good time. You had a really good time. Really, really good time. Sunday morning, you get 2 phone calls. One's from your BFF, your best friend forever. One is from Grandma. They want to know how your Saturday night went. Normally, this is about the part in the classroom where I hear snickering. Okay. I do have occasionally people say it depends on Grandma, which I guess it does. But my question for you is, are you telling them the same thing? Are you providing the same facts? Are you providing the same emphases in the facts you give them? Are you telling one of them you got home at 10 and managing to leave out whether that was AM or PM? Things like that. Are you reassuring one of them? Are you boasting to one? Are you confiding in one? You do this all the time in your normal conversation. You do this all the time when you communicate with people. You adjust the facts you provide, the emphasis you put on those facts, the order in which you present those facts, the tone you use to present those facts, according to the audience you're writing to. Why would you think it would be any different when you're doing legal writing? Okay. For instance, so goal and audience. For instance, here, take a moment. Which one of these versions of this statement works for you?
And Rick, we do have a couple phone listeners that maybe don't have access to.
Oh, okay. That'll make it harder.
Yes,
Okay.
so if we can sum up a little bit in words.
Sure. Both of these are talking about anti-deficiency provisions under the UNRRA Act and the Health and Safety Code. One of them is fairly short. The other one goes into a great deal more detail. And my question for you is, which one of these works? And my answer for you is they both do. If you look at the response in the text where this was drawn from, it says, in the 2 versions of the passage below, taken from a letter to a client, the first adopts a legal perspective, the second, the client's. The first may be appropriate for a judge, an administrative agency, or on occasion another lawyer. The second is usually best for the client itself. And the difference here, as you can see, is that it spells out more, it explains the terms a little more, it doesn't shortcut as much, which you would be free to do when you're writing to the judge who knows the field, or the administrative agency, or presumably, occasionally, to another lawyer who's also up to speed on the topic. But if you're writing to a layperson, to a client, someone who may not be as plugged into the topic as you are, then you need to explain more. The point is that there is not always one right answer. And what determines the right answer is often the situation, again, the situation you find yourself in. Who is your audience? What do they know? What do they need to know? I think as a general practice, Alexandra, lawyers tend to have a default voice. They have lawyer speak. They have lawyer formality. They tend to have it and they tend to stick to it. It's understandable because that's the way we were all taught to express ourselves legally. My argument to you is there are times when that is less than the best way. It's counterproductive. But that's how lawyers often think. So what I'd like to do is dig into some lawyer mindset. Maybe they're typical, maybe they are just stereotypical, but ways that lawyers think about things, and see if we can hold those up to the light, as I said, and see if we can come up with better answers to some of these questions, okay? So let's start with this one. I've got these for those of you who are viewing. Oh, sorry, let me do this before I left. This was just a late edition. I was at a workshop in Kentucky some years back, talking about audience, and we had a break in the session, and somebody came up to me and offered me this piece of folk wisdom, which I have been traveling with forever since. If you want to sell what John Smith buys, you have to see the world through John Smith's eyes. So how much information do you have to provide? How much difference in tone? How much shortcutting of language and acronyms do you need? Put yourself on the other side of the table. See the world through John Smith's eyes if you're trying to inform or convince or persuade or reassure John Smith. Again, it's audience. Goal and audience are the two you need. So having given you the quote to wrap up that section, let's go now again to the mindset of lawyers. There's one for you phone people. Include everything. And then in parentheses, actually don't. Michelangelo's quote about carving away, the more the marble wastes, the more the statue grows, and the story about carving away everything that's not eagle. It's much easier to do once you've decided what your eagle is, but you then do have to carve stuff away. You have to ask yourself, what will this reader need? Will the reader need all the background or just a summary? There's a reason an exec summary is called an exec summary. You've got a boss going into a meeting at 11 o'clock and she needs 3 paragraphs about the topic. She doesn't need the full memo with all the legislative history. You've got a client who wants to know, can I do this thing or not? The client needs, what does the client need? The client needs a quick answer. The client doesn't need the history. We could talk IRAC, we can talk CREAC, we can talk TREAT, all those kind of organizing principles for lawyers, issue, rule, analysis, conclusion, or conclusion, rule, etc. All those. I have a different one that I use, the most helpful that I've gotten from my workshops in answering this eternal puzzle, how much is enough, how much is too much, is this one, ATFQ, not IRAC, not CREAC, not TREAT. I tried this out in my classrooms and most people have never heard of it except for the woman who brought it into class. And possibly the reason she hasn't heard of it is it's not typically in the textbooks. It's answer the freaking question. She did acknowledge that there's some variance in the words of that subhead, particularly the third word in that subhead. But I have had people in class, when I brought this up to them, several have used the same example with me, which is if somebody wants to know what time it is, they don't want the history of the wristwatch. Give them what they need to know now. Give them what you can provide now. What's your time situation? How much time do you have? If you have an hour to complete a memo or a quick note to somebody, that should be constricting you in a good way by making you make harder choices about what to leave out, what to include. Not everybody needs everything all the time. So if you can remember that, I think you're doing yourself a service. Some people have trouble with that and they don't want to choose. Here, for instance, Alexander, would you like me to read each of these out for the folks who are on phone? Is that what we're looking for? This one I call Care for an Argument. This comes from Stark, Writing to Win, the legal writer. And he says, too many advocates treat the process of briefing as if they were a waiter at a cocktail party. They carry around a platter of hors d'oeuvres and ask judges or their readers if they'd like one. Obviously, Mr. Stark believes that part of your job is to make those choices. And that can be true whether you're writing to a judge or whether you're writing to a senior partner in a memo. I hear from many of the folks at our sessions that senior partners react poorly when you've laid out every possible choice for them and said, now you choose. They've hired you in part to make some of those choices. You made to make a at least provisional decision. So if they like it, if they agree with it, they can just basically hit send or submit and it's ready to go. But part of your job is to make those choices, to decide what is your eagle and to carve away everything that's not eagle. Okay. This is probably my favorite writer quote of all time. I took this off the wall at the Georgia O'Keeffe Museum in Santa Fe. I don't mean I pried the bronze off the wall, but I did have a notebook with me and wrote it all down. Nothing is less real than realism, Georgia O'Keeffe says. Details are confusing. It is only by selection, by elimination, by emphasis that we get at the real meaning of things. You can overwhelm people with detail. By putting everything in, you make it harder for them to focus where you want them to focus. It would be like going to a play and seeing 20 people on stage with 20 follow spots, one on each of the people. Where do you look? You don't know where to look. You're not being given any cue about what you should pay most attention to. So you have to do the selecting. I've heard a cinematographer on NPR a couple of years ago who was saying that his job in each frame is to make sure the viewer is looking at a particular portion of the frame. And I think the same is true for the art of legal writing, the same as it is for the art of painting, same as it is true for the art of cinematography. You get to choose, you get to decide, you have to decide where you want the reader's focus to be, the viewer's focus to be, and you have to make decisions accordingly to put the focus where you want it. And I call it situational selecting. Decide what that reader needs. Do they need more explanation or less? Do they need acronyms spelled out or not? Do they need terms defined or no? Do they need a special section for beginners only? Do they need a special section for detail nerds who want to dig into the weeds? And can you segregate that out from the rest of the document so that the people who don't need or want that don't have to read that? Those are all strategies you can use to try to give people, based on your audience, based on your goal, what they need at the time they need it. Are you reluctant to get rid of stuff? Everybody is. Everybody is. How do you handle that? One way I heard when I was in Boston a couple of weeks ago, which I'm happy to share with folks, is to sort of establish a halfway house for your notes. So a place where you can put something that's cut from the original document, but has not been trashed, has not been eliminated, is still there in a place where if you want to, you can come back and get it. Now, the person who suggested that also mentioned that in her experience, most of the time she doesn't feel the need to come back and get it. But having it there, having it as sort of outtakes, having it, somebody else called it a parking lot, where you can just sort of park some material you're not sure about, makes it easier for you to get rid of it initially. And having gotten rid of it, having made the move to cut it, you may in fact decide you don't really need it. And it's a little less pressure on you, this halfway house parking lot concept, outtakes concept, if you haven't thoroughly eliminated it. If you've got a file, you can keep that stuff in until you've made a final call. But let me just suggest that to you and suggest that in the same way that the cinematographer, that Georgia O'Keeffe, that any good writer, I can throw you a Miles Davis quote about writing is, that he always looks for what he can leave out. This is true across the arts. It's true across the creative world. I think legal writing is a creative art as well. But I think there's a real risk of overwhelming busy people with more material than they can handle, more details than they need, more information than they have time to cope with in their current situation. So to the extent you can get rid of those things, make good cuts initially, that's a help. I'm going to hold for a second here. I'm about to ask you another poll question, but let me pause or at least give you a minute's notice that we are open for questions at this point. It's a good logical break point. We're about a third of the way in. And why don't we give you a chance to write questions on the stuff we've been talking about or anything that were unclear in the kinds of concepts I'm offering you and sharing with you today.
Wonderful. So thanks, Rick. We do have a comment from a listener stressing the importance of tone. And it used to be that a transaction required several meetings, but now so much is in email and tone really matters. But we've lost the ability to assess tone of voice, eye contact, body language. So how something comes across in writing is more important than ever before.
I think that's true. I think it's a great comment. We'll be talking about tone in the final third of our session today, but absolutely, as the platforms change, I remember an editorial writers group I was active in that went online some number of years ago, and I would say within about 3 minutes of the first discussion, there was a misunderstanding and an argument because somebody had said something that they meant sort of offbeat or sarcastic, and sarcasm wasn't really coming across. And so there's absolutely that danger, and I think we want to talk about, and we will in a little bit, if our listener commenter will wait for just a little, we'll be getting to tone as well. But I think it's very important, and I have some suggestions about that as well.
So please continue to submit your questions and comments. I think for now we can move on, but if you think of one, for sure, pop it in the question box and we'll get to it.
Absolutely. Let me go through a question from me to you, if I can. These are questions I think you ought to use in your situational selecting, which we've just talked about. Questions you can ask yourself: who's receiving your document? What do they need to know now? How much time do they have? How much expertise do they have? How familiar with the case are they? You need to have answers to those questions to the extent you can get answers to those questions before you make the good selection choices. Okay, so that sort of sums that piece up. Let me go to, actually, let's go, do we have poll question 4? Your preferred method for preparing to write a legal document. Do you want to put that one up, Alexandra? Let's do that one.
Absolutely. So when you're preparing to write, what is your preferred method? Do you outline? Are you more of a free writer and just do a brain dump? Do you use mind mapping or something else? And if you use something else, tell us what it is in the chat.
And by mind mapping, I have in mind also something that is called a whirlybird, which some of you might be familiar with. It's sort of a center and spokes arrangement, but it helps people find relationships among different topics and concepts. And some people find that very helpful.
All right, we'll give you a couple more seconds to weigh in and then end the poll. Here we go. Let's see what people use. So vast majority use outline.
Interesting. Okay.
Followed by a few using free writing and mind mapping.
Okay. Okay. I found it's interesting. The people I have found primarily using mind mapping and things of that sort have tended to be in tech-related legal fields. For some reason, relational databases and things of that sort are a better fit for them. I will make a case for a couple of these things in a moment. I think some of them have advantages that others don't, and we'll suggest a couple of them in some pairs of concepts. Let me go back to the sort of the lawyer's mindset a little bit. Here's one that I see some lawyers struggle with fairly often, lawyer writers, that they feel they have to start writing immediately, especially when time is short and also when time is long. And my answer to that, as you can see down below, is really? This is Brandeis sarcasm coming forth here. I should tell you that I've had, when I was doing a column, which frankly started when I was at Brandeis at the Justice, people would occasionally say, how long does it take you to write a column? And I'd say, well, when I was doing my syndicated column, I'd say, well, I would sit down maybe 7:30. I'm done by about 10:15. I've polished it up. I'm hitting send. Granted, it's not a legal document. It's short. It doesn't have a ton of material. I have to wrestle to the ground. But a couple of hours. But I said, that's a trick question. If you mean how long does it take to write it, if you only mean fingers on the keyboard, I think that's a misconception. I think a lot of the writing occurs before you start writing. In my workshops, I even have a section called The Writing You Do Before You Start Writing. I think it's essential to many people to make good decisions about their writing, to not feel they have to start with their fingers on the keyboard and start putting something out. I think even if you have a short period of time, even if you only have 60 minutes to do some memo for somebody or a letter to somebody, I would suggest spending the first 8 or 10 or 12 minutes of it thinking it through, thinking the situation through, thinking about the kinds of things we have been talking about before you start writing immediately. I think even with a limited amount of time, you'll make better decisions. and you'll take those other 45 or 48 or 50 minutes and make better use of them rather than just flailing away, okay? Conversely, I told you some of these are going to be paired concepts. While I wouldn't suggest writing immediately, I also wouldn't suggest, there was the poll going by there, make sure, some people think you have to make sure, and I've heard this a lot, people look at the blank screen and they freeze because they are trying to compose the perfect first sentence. I would ask for a show of hands about how many of you have that issue occasionally, the sort of the blank screen or the blank page panic, and you're trying to create the perfect first sentence before you go on to the next one. It's a roadblock. I would advise against looking at the need for perfection. I have a clip I use occasionally, that a piece of advice that says, your first draft is crap, that's okay, because you're coming back. The deal you make with yourself is you're coming back. For people who are disinclined or nervous about looking at the blank screen, I think in many cases, free writing, which I had noticed just some of you had suggested, is a way to go, so long as you don't require yourself to be perfect right from the jump. You can just start pouring things onto the screen and organize them later. I have had journalism workshops I've done in the past where I had a participant say that her advice when she got blocked, couldn't get started, was to write the words "once upon a time." Okay, she'd write "once upon a time." She knew that was coming out. She knew that wasn't going to be in the final document, but it got her over the hump. We are wired to tell stories, to hear stories, to listen to things in a story thread manner. And so she found out if she used "once upon a time," she would start telling the facts that were important and introduce the characters that mattered. And she knew she was going back and cleaning that up. She knew she wasn't telling it that way, but it got her over the hump. Okay. I have had people suggest that if you're stuck, you put the caption in first. Where's the date? What's the procedural situation? That you just do a description of fact. Some people prefer the fact description to come after they've decided what they're writing, as they sort through everything they've poured on the screen. Again, there is no one right answer. If you are hung up on having to be perfect, free writing may be a way over that hump for you. If you're somebody who needs to have things organized much more coherently, much more linear fashion, then outlining may be the way to do it, to make that easier for you. And then the relationship databases are also available for people who don't want to commit to a particular sequence of facts and figures, the way an outline will with Roman 1 and Roman 2 and capital A and capital B, but are able to see relationships among facts, among details better in that format. Any of those works. I do sort of personal testimony for outlines in my own case, but I also point out that when I was doing columns, I would virtually never outline. I would do maybe a 3x5 card with a couple of phrases on it. But as I did longer legal documents, if I did longer magazine pieces, feature pieces, then I had an outline that was virtually line for line. And let me tell you why. And again, if this works for you, fine. If it doesn't, that's fine too. But what I found for the long pieces, when I had to wrestle lots of material, is if, say, I had 6 cases that I was thinking of using, and I looked them over and I said, okay, these 3 are from a circuit I need. This is one that's too old. This one is redundant of something else. I'd make my initial call on which 3 I was going to use, which 3 I wasn't. Likewise, if I had a half a dozen quotes that I thought were relevant or possibly relevant, this one's more recent, this one's from a more prominent person, that one I've already quoted before, I don't want to use her twice. So I'd make those kind of cuts. What I found it did for me, and I'd make those cuts in the outline, at the outline stage. What I found that did for me was it separated those first 3 questions, the what's in, what's out, and where do I put it? Those 3 questions from the how do I say it question. And it freed me to do the best writing I could when the time came to do the writing. That I didn't have to most of the time stop in the midst of the paragraph and say, okay, now which 3 of these do I want to use? Which 3 cases, which 3 quotes do I want to use in which order? I had already made those cuts. I'd already made those choices. And so it helped me keep the flow of the writing up and allowed me to be the best writer I could be at that point, having already made what I thought were the best choices I could make about what's in, what's out, and where to put it separately. Now, having said that, does that mean that if you're in the midst of writing your document and you suddenly realize or gradually realize that there's something else, one of those other three actually works better now, one of the three you had parked in your parking lot in your outtakes, that one of those three actually works better and you'd like to sub it, or you'd like to add a fourth one, or you'd like to switch the order in which they occur? Of course you can. It's your document, it's your tool, it's for your use to help you. But I have found that by and large, if I can make the what's in, what's out, where do I put it decisions separate prior to the how do I say it decision, it improves both ends of it. And particularly on the writing end, it frees me up to be a better writer, to be the best writer I possibly can. Okay? So there's that tip. Again, if it works for you, I'm delighted to have you share it. But the other piece of the other sort of mini lesson you might take from this is, even there, I've told you I don't use only one method. Depending on the situation, if I'm writing a shorter piece, I'm less inclined to have to need an outline. If I'm writing an email, I'm less inclined to have to use an outline. If it's when I'm wrestling more information to the ground, or trying to, that it becomes more necessary. So that's what I tried to do. Okay, let's move on to another writer hang up, if you will. Some writers feel obliged, and again, this will be a paired concept with the next one. Some writers will feel obliged to write the thing that's appearing in the document first, the thing that's appearing in the document next, and so on, right on through the document until they get down to the last part. Can you see where that might be a problem? It might be a problem because, as we were talking about, you might have writer's block, and writing just the summary will be better, a better starting point than what the document itself is going to finally contain as its first paragraph. You might find that the summary of argument that will be on top of the document comes more clearly to you, more coherently to you, once you've seen how the facts lay out as you've written the rest of it. There's nothing wrong with that. You can come back. Cut and paste is good that way. You can come back to that. But you shouldn't feel obliged, hemmed in by the final format of the document as to what is most productive in terms of how you sequence the writing itself. Okay. Likewise, some writers feel that they've got to put in whatever facts they're going to include have to be presented in chronological order. There are writing gurus who disagree with that. Take a peek at this, and again, for you on the phone, this is from Stark, Writing to Win, and I've titled it, What Goes Where, Maybe Not What You Think. And Stark says, after the initial paragraph, and my apologies to those of you who are already reading it without the telephone, but we're going to try to get everybody in. After the initial paragraph, lead with your strongest facts. Don't feel compelled to tell your story chronologically. Like judges, almost all litigators relate their facts chronologically, beginning with the event that happened first in a historical sequence, proceeding forward to the present. Stark goes on to say, this is probably the worst mistake most litigators make in their writing. It talks about how modern novels, short stories, movies rarely begin with what happened first. They start instead with an important event. Then the narrative proceeds with the author filling in earlier facts as background as the plot moves along. And he goes on to conclude, the only two groups left who tell stories chronologically, at least in American culture, he says, are lawyers and 6-year-olds. How was school today? What happened? Well, this is me, not him, although I'm paraphrasing. Well, I got off the bus and I went into the class and Mrs. Collins said hello, and I took my coat off and I sat down and I said hi to Jimmy and I said hi to Colin. Lawyers don't have to write that way. We haven't been 6 in a while, right? Okay. Likewise, particularly when you're doing litigation, do you need to let your opponent's document dictate the sequence and the emphasis that you give to your response? Or as I put it, why are you such a wimp? You may feel the need to respond to each of the points your opponent makes, the other side makes. But most of the folks I have read and consulted with and heard from suggest that it's a mistake to let your opponent dictate the sequence, and emphasis. The fact that your opponent makes some argument first, gives it most prominence, doesn't mean you have to address it first, doesn't mean you have to address it in great detail. Often much more effective is tucking it in, dismissing it with almost a wave off. This is, not something we have to spend a lot of time on. It's a loser argument for the other side. We acknowledge it, we nod at it, we show we've seen it, we show we've heard it. Here's our quick answer. And that's the third of four. You've already talked about the ones you want to talk about. Or you can dismiss it early at the start and then say, let's get to the ones that really matter, and you can discuss those. But it's a mistake, and some lawyers feel obliged to respond to the other side using the other side's framework, and I think that is less effective as a general guide. Your job is to make your best argument. Your best argument. You may have to respond to something, but you don't have to emphasize it, and you certainly don't have to put it in the sequence that your other side has put it. I would often stop and say any questions here, but we'll stop for questions in just a moment. Let's go to some other lawyer mindset questions. This is a real danger. If you understand the flow of your argument, so will they, is the quote I've got here. The problem is what? The problem is you typically know more about the subject than many of the people you're writing to. The danger with that is that you start to assume knowledge that is not generally held, that is not commonplace. And so you tend to shortcut in places that shouldn't be shortcut. That it's always helpful to, again, put yourself on the other side of the table, see the world through John Smith's eyes, and find out whether there are decide, I guess, rather than find out, whether there are things you can do in your document to make clearer to the reader, who, for argument's sake, is not as up to speed on this topic as you are, where you're going, what comes next, why it comes next, what you're going to be hearing about, what you should be focusing on as a reader, and know which topics are the things you should pay attention to, most attention to, what are things that are sort of pertinent but not crucial, and what things, presumably you've left most of these out, are not either pertinent or crucial. Just take them out. But subheads will do that. Summary paragraphs, some people call them umbrella paragraphs, to sum up not sum up, to tease, to give a little preview of what's going to be coming, or a summary at the back end of a section to, in the old words, the old line about tell them what you're going to tell them, then tell them what you told them. The summary can often be helpful to do that. And even something as small as transition words to let the reader know whether this next paragraph or this next section is a further detail on this point, or a contrasting point, or a counter argument, or a nonetheless, or a as a result, cause and effect. How does this paragraph relate to what came before it? How will it relate to what's coming next? How does this section relate to what came before it? How does this section relate to what's coming next? Okay, you can help them. Don't assume that because you understand your argument and it's logical to you, it's going to be logical to them. Okay? You can help them. Here's an example, just on your screen. For those of you, I don't even ask people in my classes to read these in full. I just say, if you had these presented to you, which one would you be more likely to read? Which one would you be more likely to understand? For you phone people, one of them is a big block of type, no breaks, no air, no nothing. The other one, the after version, has subheads. It has bullet points or numbered parentheses bullet points. It has shorter paragraphs. It has airspace. It is a much more readable document. Even though it takes up more space on the page, it's much easier to read. And so giving your readers help along the way is very helpful. And again, the paired concept, eventually they'll figure it out on their own, sure, unless they don't. There are, some of you have heard of Emily's List. In political seasons, it's an acronym, EMILY, which stands for Early Money is Like Yeast. It's primarily for liberal women candidates There's a comparable group whose acronym is escaping me at the moment on the other side of the spectrum. But early money is like yeast. If you can, it helps raise money to have already gotten some money. To be able to show you're a contender, you can then raise more money. The early money does that. I think in the same way, early guidance is like yeast. I'm not yet at the point of calling it Eggley's list, but you might think of it that way. If you can give your reader early guidance, it's tremendously helpful to them. It can be, different people have different words for this. Words I particularly like and offer to you are a frame for what they'll be looking for, or a lens through which to be looking at the stuff that's coming up. You're telling them, this is what this case is about, or this is what the subject matter is about, so pay attention to things that relate to this. Pay most attention to these kind of things, rather than just throwing a bucket of information at them and hoping that they will sort out, without any guidance from you, where they should pay their attention. And you notice we're sort of back to the cinematographer again and his comments on NPR about trying to find a place where, trying to create a place where you as the viewer are going to be looking and paying most attention, even though there are other things in the frame at the same time, even though, to use my other example, there are other people in the spotlight on the stage, but you put only a couple of spots so people look where you want them to look. Let me show you, I think we've got it here. These are two versions of FCC, Federal Communication Commission regulations, a before and an after for citizen band radio. Does anybody, I tend to ask in my classes for a show of hands of anybody who's old enough to remember citizens band radio. There are fewer hands all the time, I can tell you. I describe it for people as sort of social media for trucks, okay? But you have two versions of regulations here. And if take a moment and just look at the two sets of subject headers. And again, for you phone folks, first one is authorized frequencies, policy governing the availability of frequencies, limitations on antenna structures, transmitter service and maintenance, transmitter power, and external radio frequency power amplifiers prohibited. The second one, the after, on what channels may I operate? How high may I put my antenna? What equipment may I use at my CB station? How much power may I use? And may I use power amplifiers? Can you feel the difference in those subject headings? What's the difference? The second one sounds like actual questions actual people would ask in language they might use to ask them. Okay, they're all written in the first person. You could write them in the second person and they'd be about as effective. On what channels may you operate? How high can you put your antenna? And that would work too, but they're both more personal address. They sound like frequently asked questions or an FAQ list. Whereas the other one, not so much. You'll also notice, and I didn't notice this until several months into using this, someone in class did, that the first set has the pertinent regulations at 95.455, 457, 437, 511, 613, and 509. They're all over the lot. After, 95.407, 408, 409, 410, 411. If you want people to find information, you might want to make it easier for them to find it. So a question that's formed in the form of a question that's first or second person, so more accessible. We were talking about tone before from the commenter. This is one example of that. And questions, information that's organized in an easier way to find. All the questions about Citizens Band Radio, all in one consecutive set of titles, okay? Now, let me tell you, I showed this, I've been showing this for quite a while now, and I had somebody in one of the classes, after we had talked about why the second group is advantageous, the second formulation, and he said this: I guess for the public, it's nice. There was clearly a but at the end of that sentence that he didn't think it was necessary. What was this topic? This topic is Citizens Band Radio. Citizens, right? Public, citizens. If you're ever going to do a regulation where you'd want it to be nice for the public, wouldn't Citizens Band be the one? Why would you not want to make it easier for the public unless you're thinking you get more billable hours if somebody needs you to translate the regs for them? But if your assumption is that most of the time you'd like to be clear and you'd like the things you write and create to be clear to the people you're writing them to, and there are exceptions, but why would you not want to have something be clear to the public? Okay? So think about that. And when you, again, this comes down to John Smith's eyes, doesn't it? Put yourself on the other side of the table. Are you writing to somebody who knows this stuff well, or are you writing to somebody who doesn't? Are you writing to somebody who's going to need a hand up or not? You don't want to condescend by just explaining things you don't need to, but you don't want to leave somebody in the dark by not explaining things that need to be explained, or using language that can't be understood, or organizing it in a way that can't be found. So think of the social media for truckers and trucks and figure out if there's a better way, better tone you can use, better organization of your information. Okay, we move on. Let's see. And we'll pause for questions in just a minute or two. So if you want to start putting some questions in. In terms of, we've talked about putting things in and putting things out, sort of big picture. I also talk in my workshops a bit about sort of more granular, down to the actual sentence structure and, you know, what the words look like on the page. Do you believe this? Do you believe the longer the paragraph is, the more persuasive the argument is? And my, you know, tongue-in-cheek comment below it for you phone people is, tell it to the judge. Would you want to read this? Would you be able to read this? I have titled it "One Large Gray Mass" for a reason. Are you likely to understand it? Are you likely to even dive in? Feel you need to dive in for it? I hear more often recently, even than when I started doing these workshops, about how busy the people they're writing to are. They're flooded with information all the time. Why would you want to add to the flood? Why would you want to make it harder to grasp for somebody who's looking at a document for the first time, rather than simpler, easier to grasp? Okay. Likewise, the more clauses in your sentence, the more information you're conveying. And I ask here, are learning and yawning really synonyms? You're not conveying more information because the sentence is longer. You're making it more difficult. I ask people in my workshops, I offer them extra credit for the non-existent grade, the imaginary grade, if they can find a period in this document before you get down to the last word of the last sentence, last word of the sentence, the last line of the page, other than California Penal Code 631A. There is no period here anywhere in this sentence. Why would you do this to somebody? Why would you do this to somebody? Again, assuming what you want is to be understood. Okay? Assuming what you want is to be understood. Now, I had somebody in class early on, a veteran attorney, who said that his job, I'm paraphrasing here, but I think I've got it about right. He said his job was to write documents that would permit the citing, that's S-I-T-I-N-G, putting them on a site, the citing of storage tanks that contain tens of thousands of gallons of flammable material closer to residential areas than one might think prudent, and to bury that fact. It's a living. But in that case, yeah, and there are other cases where you don't necessarily want to be clear. But on the assumption that the vast majority of the time you want the person you're writing to understand what you're writing to them about. Look at your sentence structure, look at your paragraph length, see if there are ways to break things up, subheads, airspace, just an indent, just a shorter sentence, just a shorter paragraph, a standalone sentence to highlight the thing you most want them to focus on. We're back to cinematography again, aren't we? But see if there are ways of doing that, okay? Can you cut out the unnecessary words? Can you cut out the throat clearing words, okay? I have just an example here. We do in class occasionally. The writer of this textbook distinguishes between working words, which he says carry the heavy burden, and glue words. I'm not crazy about the term glue words because he's trying to tell you that those words aren't as important, and I think that's true. I'm not sure that glue is the best way to describe that, because glue actually is important to holding these things together. But if you see here, a trial by jury was requested by the defendant. It's a 9-word sentence, and the writer breaks that up into 4 working and 5 glue words. And I invite people to make their own fix here. How might you change that so you're getting rid of some of the unnecessary words? Likewise in the next one. The ruling by the trial judge was prejudicial error for the reason that it cut off cross-examination with respect to issues that were vital. 24 words, only 11 are working words, he says, and 13 are glue words. Do you need the ruling by the trial judge when you can say the trial judge's ruling? Do you need for the reason that when you can say because? Do you need with respect to when you can say about? Can you say with respect to vital issues, about vital issues rather than issues that were vital? It may not seem like a lot. It's only a sentence. But think about it. That sentence shortened, followed by the next sentence shortened, followed by the next sentence shortened, per paragraph, per page, per document. You're making it a much tighter, crisper, cleaner read. These sentences don't lumber, they move. They're clearer, they're easier to understand, again, assuming you want people to understand what you're saying. So you can get rid of those kinds of extra words without costing you anything in content. There's a habit we lawyers have of using more words to say things than we need to say. So I won't say anything more about that. But I will open it to questions, Alexandra. We're 2/3 through. We're at noontime in the Central Zone, 1 o'clock in the East.
Yes, so one of the questions we've gotten in actually relates to tone, which I think you'll be getting to.
Yes, indeed. Coming right up.
Next. And
yeah.
So it's an interesting one. And so maybe as we're
Sure.
moving to that section, you might want to mull it over.
Okay.
It's how do you address training your staff to respond to other attorneys who are rude over email or speak down to them? And so I think you could probably, insert any career field here.
Yes, yes. I had someone in Boston 2 weeks ago who said that she's been hearing from somebody who likes to throw Latin at her. And she's absolutely convinced it's for the purpose of making her feel smaller. Yeah, there's still people out there doing that sort of thing. I would say polite, firm, stick to it. You probably don't want to get an argument if you're arguing up. It may be something your senior partner might want to handle at some point. But yeah, we'll talk about tone. I think it's good. Any other questions you want right now?
Not at this time, but just a reminder, please begin submitting them. You can ask them at any time and we'll ask them at the breaking point, or if it's a clarifying question, I'm happy to interrupt Rick.
Okay, and now we're going to talk tone for a little bit, okay, for most of the rest of our time, actually. Wow, then with legal jargon and technical language, or would you rather be understood? Can you see, even though we've segregated these into separate categories and separate pieces of the lawyer mindset, how many of them weave together? That depending on who you're writing to and what you're trying to accomplish, are you trying to impress? Maybe the technical language is good. If you're trying to snow somebody, maybe the technical language will accomplish that. You remember the verbs included things like harass and threaten back earlier in the session. But assuming you want to be understood, how much legal jargon and technical language you use is a real determinant of how you come across and how effective you'll be as a communicator, as a lawyer writer. Now, I had I think the very first session I did for DC Bar, let me see if this is the slide coming up. If I don't use words like herein, this person said, clients will think it could have been written by an intern and they won't want to pay the rates we're charging them. Okay. I often ask for a show of hands how many people agree with this. More often I get people chuckling ruefully. I have had some people who agree with it. They like the use of the legal words. It justifies going to law school. It justifies, the tuition. But I also pair this quote, with another from one of the textbooks we use. I have never yet met a client who has said, please write me a letter I don't understand, because then I will think that you are smarter. Okay, now as between these two, this one, you won't be surprised to hear I tend toward the second. Okay. Again, on the assumption, and I wind up just almost putting this in a quote box and put it up on the screen, assuming you want to be understood. Why would you use the others? Why would you go to the doublets, the triplets, the give, bequest, and devise? Those kind of things. I've heard 3 different explanations for some of the habit of lawyers to double up and triple up on phrases when they don't need to, or to throw Latin phrases. And I even put a list up occasionally and ask people to, to pick their favorite ones. I will tell you that silencio gets good ratings from people. Inter alia does all right, but a lot of the others not so well. Arguendo is a popular one. Doesn't take much longer than the actual word. But if you're writing to somebody who's not going to know what inter alia means, you may be impressing yourself. But maybe you're not impressing anybody else, and maybe you want to. I've heard three explanations for that sort of doubling up or tripling up of language. I don't know if any of these is true or whether they're all sort of urban myth. One is that the English language came from twin streams of Roman and Anglo-Saxon, and so both words were kept as the law developed over the centuries. The second reason is that the difference between law and equity, they had different linguistic quirks associated with each of them. And so as they merged, both the terms were kept intact. So that's two. The third one I heard, and again, these may be just urban myth, is that the scriveners who wrote this stuff centuries ago were paid by the word. So they had a profit motive to put in as many words as they can. Presumably, for most of us, you don't have a profit motive in making your language impenetrable. So I would urge you away from it, while understanding that it's a frequent default for lawyers. Steven Pinker, the noted writer about thought and thinking, has this I've come across recently. When you enter graduate school, you enter into a tiny clique, a subset of your discipline. Your estimate of the breadth of the knowledge of the people you're writing for gets radically miscalibrated. Highly idiosyncratic ideas are discussed as if they're common knowledge, and you lose the sense of how tiny a club you have joined. And you're in terror, he says, of being judged naive and unprepared, and so you signal in your writing that you're a member of this esoteric club. I think that is absolutely true when it comes to lawyers. And it's true, frankly, of most fields. Everybody's got a secret handshake. Everybody's got a secret set of language and linguistic codes that they use. Sometimes they use them deliberately to exclude. We're part of the club, you're not. Sometimes they use them inadvertently. Do any of you remember first-year law school when you and your classmates would be telling torts jokes with torts concepts as the punchline? You were cool, right? You knew tort words. You didn't know tort words before. Give it another couple of years and you forget that the words you're now using are not commonplace, and you didn't know them a couple of years ago. A lot of people still don't, but they've become so natural to you, you tend to throw them out there and assume everybody else is going to understand them. But that is true of many fields, but it is, I think, perhaps particularly true of lawyers. And it calls for a real hard decision about remembering who you're talking to, what you're trying to accomplish. This one from Kimball in Writing for Dollars. And again, assuming we still have phone people on. When a writer does need to use a technical term, he or she should consider whether to explain or to provide examples, explain or define it or provide examples. And Kimball goes on to say it's probably the toughest call in drafting. And again, see how often this comes up. It often depends on who the intended readers are and how difficult or unusual the term is. You would not define indemnify in a commercial contract between business parties, but you probably should in a consumer contract, such as a car rental. Again, who is your audience? Will they understand the language? Do you want them to be the language to be understood? It's context, it's situational, and you need to make those calls and be aware of them. I have suggested to people that these two firms, Smythe, Witherspoon, and Thistlebottom, and Jones, would probably write differently. They have a different presentation they're trying to make. And the way you choose language can help you make that call. I ask people to think about adult male, man, gentleman, fellow, fella, guy, dude, bro. They all are supposedly definitions for the same thing, adult male. You may disagree about bro, but they have they connote very different things. And it's important for you to know that. I'm not, by the way, arguing that all the time it should be the less formal, the more conversational, although I do think more often than lawyers tend to use it, it ought to be. Because again, you're not always writing to experts in their field or in your field, okay? Are there examples where where the other way is better? Absolutely. I had somebody in our DC class a couple of months ago who had passed a church on the way to our session, and the church had these signs in front of it. Park not, lest ye be towed. So it can work. It can work. But by and large, if lawyers can avoid the fancier word for the clearer word, I think they're doing themselves, and mostly they're doing their clients and other people they deal with, a great service. This is on the back end of my business cards these days, just so you know. Commence immediate avoidance of all jargonization processes. Yeah, because lawyers tend to talk like that. Lawyers should not talk like that. Lawyers are drawn to talking like that, which is why my next last mindset tip is, above all, make sure you sound like a lawyer. They'll be so impressed. I do a survey in my classes about ways people make decisions that can affect how they come across. Often they come across, as this slide does, lawyer communicating as sort of the sunbeams breaking through the clouds and giving us the benefit of your knowledge. But even smaller choices in just individual words. I do an instant survey in class. I ask people, are you a so or are you a therefore? Are you an and or a moreover? All right. I am an and who is married to a moreover. We're considering couples counseling, I tell people. But she was the copy desk chief for a major metro newspaper, and she would no more start a sentence with and than she would jump off a roof and try to flap her wings. Doesn't happen. Can you use sentences that start with and? Sure. Can you, even legal documents, I've shown in class, they do that. Do you go with therefore, or do you go with so? You convey a different sense of tone when you do that, the choices you make. So consider it situational tone. Can you use conversational words in your language or not? Do you use contractions? I asked a session in Boston earlier in the year, how many of them use contractions in their writing? And maybe one, I said, how many use it in your legal filings? None of them, virtually none of them did. Some of them in emails or something. But then I had somebody who said this, my favorite quote for the entire session. We use contractions, but we're a nonprofit. And I think she was right in a way, that the way she conceived of her audience as a nonprofit was less formal, more informal, more conversational, more person to person. And so saying I can't rather than I cannot, or you won't rather than you will not, was the right call for her. Interesting though, I ran this slide up at a session a couple of weeks ago, I guess it was, and someone in the room contributed the fact that she too works for a nonprofit. And she said her group made a conscious decision not to use contractions because they were worried about not being taken seriously by the rest of their legal community as a nonprofit. And so for them, the idea was to serious it up, to up the tone a little bit. And so their decision was to avoid words like that, like can't or won't and shouldn't, and use the full spelled out, more formal form. Again, neither of those is the right decision. But what you have to do, what I ask you to do, what I hope you'll do, is to assess the situation you're in, what you're trying to accomplish. The first of those nonprofits was trying to put their non-lawyer client readers at ease. The second of those nonprofits was trying to be taken seriously by the rest of their legal community. And so they made a different choice, even in words, okay? So it's something I always say, get to decide rather than have to, because I think it comes to control of the material. And to the objection you get from some people who feel that, all their legal training is not being used and that it's dumbing down, I say this, it's not dumbing down, it's clearing up, okay? So with that, I will throw one more slide at you and just jump past, and then we'll open for whatever remaining questions we have. There, when you know your stuff, why bother with proofreading, except it's not. Your credibility is at stake on that stuff. I know it seems beneath us to care about that stuff, but you really need to know what the proper spelling of the word it's is, and there are only two of them. third one is not found in nature. You really have to make sure you got your punctuation right. You really got to make sure your spelling is right. People will just simply assume if you can't pay attention to the small details, why should they trust you on the big stuff? So by all means, find methods. I've heard and shared methods that go for everything from reading out loud, which I think is terrific, particularly for figuring out if you're repeating phrases and repeating words too often, or if the transitions aren't clear, to reading from sentence by sentence from the back end of the document to make sure you haven't filled in your head something you haven't actually written on the document that you think is there because you expect it to be there, to having somebody else read it to you, to printing it out on paper if you've written it on a screen, to printing it out in a different typeface so that you're reading it with fresh eyes or hearing it with fresh ears so you can catch those kinds of things. I think it's important to do because you're spending enough energy trying to be taken as a helping and serious person. You want to make sure the person you're writing to has confidence in your ability to do both those things. And with that, Alexandra, why don't we hold it at this point now? And I've got one or two other things I can go to if we need them, but let's give the time promised at the back end for questions about this or any other related topics that we've addressed or leaned toward. Does that work for you?
That works for me. So any questions, please submit them now or forever hold your peace. We do still have the lingering question on addressing training with your staff on responding to other attorneys who may be taking a not so good tone via email.
My own answer, if somebody else with more experience working with a staff, I'm a solo, I'm a solo act at this point. So I haven't had as much occasion to do that, but my own sort of gut reaction to that, while I wait for somebody else to come in with more expertise on the subject, is that you don't want to get into a pissing match with the other side, that you want to keep your side of the thing professional, that you can perhaps use in your basic air quote the phrase to show that you've seen it, you've heard it, they know you've taken note of it, and yet you're still going to respond in a professional way and use professional language. I think it's harder if you're a junior person. I'm assuming from the question, Alexandra, I'm not sure if you said whether the person writing it is also senior to you or whether it's some other young person at the other end trying to make a big impression by coming across that way. Was that specified?
It's unclear.
Okay. I heard the question as sort of somebody sort of senior is dumping on you and you're having to be trained to resist the urge to try to shout back. And I think that's probably where I would come down, that you're trying to keep it professional when you can. And I don't think there's much to be gained by getting into a shouting match with folks. Sure. And again, if anybody else has had this occasion in their own staff, either as the senior person or the person being trained, and wants to check in on the chat box with that, I would be delighted to hear from it. In a normal class, we'd have this kind of back and forth.
Exactly. So you mentioned punctuation as it relates to proofreading, but this listener is asking, do exclamation points ever have a place in formal legal writing?
Wow.
Unless part of a quote.
I would say unless part of a quote. I think you can do somewhat the same thing if you're trying to get emphasis. I don't hear, from the people I've talked to, from the people I've read, I don't get anybody who is comfortable with them in formal writing, which is what the question was. That doesn't mean you can't use them in your email, in your memos, things of that sort. But I think there are other ways to make things stand out and emphasize them. One particular favorite of mine is the short standalone sentence, a sentence that gets its own paragraph, that is brief, punchy, to the point. You don't have to be putting the exclamation point in there to basically be saying, you want to pay attention to this one. I'm standing here by myself. Everything should be looking at me right now. There's air around me. There's white space around me. I want you to look here. I think you can do that. And as much as I'm a fan of more accessible conversational writing, I have, I think, held back on exclamation points in formal stuff. But again, as I said earlier, I have been showing opinions from DC Circuit, I think recently, that Foreign Agent Registration Act cases that used a sequence of sentences that in the third sentence started with "and," because the first one was the basic statement, the second one was this and such also, and by the third one they needed someplace else to go. And so for all of the supposed formality that you can't start a sentence with and you certainly can't start it with and in a formal setting, there it was right out there. And you know, the world did not fall down, the earth did not stop rotating. So I would say in some cases, yes, I would probably personally draw the line on the exclamation point, but I think that's because you've got other ways of doing it.
Right.
Other options available to you.
This question, I think, is referring to alignment preferences. So ragged right or justified.
Let me suggest a book by a gentleman by the name of Butterick, Butterick. It bears the totally exciting title of something like Typography for Lawyers. It's a slim volume. If I could reach it here, I would show you, but we're not on camera. It's a slim volume. I think it runs about $28, and it covers in greater detail than I can. And some of this varies according to the court, according to the circuit, whether they want things ragged right or not. I think as a general matter, I find ragged right easier to read because there's a little bit of airspace if you have a choice, rather than that solid block of type we showed you before, that large gray mass. But I think you can also accomplish somewhat the same thing of airing it out a little bit and giving people's eyes a place to rest by having shorter paragraphs, by having subheads, by having chapter headings. Things of that sort can also break it out. But there are, as I understand it, there are different rules in different circuits. And again, as someone who's not advocating revolution here, I think that going with what the circuit requires is the way to go. But I think, again, there are other options to, if the purpose is readability, then I think there are other tools you can use. But again, I think Butterick, now let me tell you a little bit about the book. He does design some of his own typefaces, and he does sell those for money. But the book is not a promo book. It's actually quite good. I get nothing from it except that someone in one of my early classes recommended it, and I found it quite good, and covers all those sort of best typefaces for this, best alignments for that, how many levels of type font do you want to go down in your outline or in your document, what sort of typefaces are better for certain purposes, why you should virtually never use underlining anymore except as a link. And his point about that is that you used to, in the days of typewriters, for those of you who answered that 20 years or more question about your experience, there weren't very many ways of distinguishing type. But now you have small caps, you have boldface, you have italic, you have various things you didn't have before. And underlining is used for other things, so using it for emphasis only confuses things. But anyhow, I think it's worth your investment if your shop doesn't have it already. It's by Butterick, and it's called Typography for Lawyers. And I think you'll find some really useful material in there as well.
Wonderful. And as someone who manages websites as well, personally, the underline right absolutely can't be used. It's always a link now. So if you're about writing for online audiences as well, that's something else to take into consideration.
Exactly. They're going to be clicking on it, expecting to be taken somewhere, and they're not being taken anywhere other than into frustration. So again, why would you do that to people when you have, again, other options to do the same sort of thing? You know.
We did get some feedback from one of our listeners in response to the question about not nice tone from other attorneys.
Please,
and I think
good.
it's wonderful advice, so thank you for sharing it. This person believes incivility should always be met with civility. Perhaps calmly use words like, I'm disappointed in the content or tone of your email or communication. This person also recommends asking for a meeting or a phone call, which is both respectful and positive from your side and not a sign of weakness. Their experience is that people tend to back off and apologize, and the more personal contact itself may create future cooperation. I think we see this, playing out in chat rooms and reviews on Amazon all the time. Sure. That people do tend to get a little more emboldened in writing, and so getting someone face-to-face or on the phone could certainly help improve this. I think that's a great tip.
I think that's right. I thank you for that suggestion. You would need to be able to convince yourself that you will not lose it on the phone, and you will not be psyched out on the phone if the other person continues to put up that same kind of aggressive manner at you. But yeah, I know when I used to write my syndicated column, occasionally I get a call from an angry reader, and the first thing that they heard was my picking up the phone myself and giving them my name. And you'll be amazed how much that backs the reader off when they realize, A, they're talking to an actual human, B, they're talking to the person they were complaining about, and he sounds like a normal, rational human being, at least some of the time. I try to. And that it's not something you can just pass sort of anonymously through some secretary or aide or clerk or something, but have to own up to yourself in your own voice to the person who'll be hearing it. So yeah, I think that's a great suggestion. And I think the civility, the overall point, meet incivility with civility, is generally the way to go. Yeah.
So we know from your presentation that you love quotes. That is
yes.
clear. But this next question asks, how do you feel about using non-legal quotes and citations to non-legal sources when writing legal briefs? Time and place.
I think I'm a fan of making the best argument, telling the best story you can. And if there is something that is outside the direct field of law, but pertains and clarifies or emphasizes or reinforces a point in an easy to understand way, you may also want to have a case from the Ninth Circuit in there, but there may be a quote that is pertinent. There's a reason some of these quotes have lived as long as they have, and that's because they're applicable in many different situations. So I would say, yeah, I would go for it.
Wonderful.
Just my own opinion, but I would go for it. Happy to hear opposition to that, but that would be mine.
So in the few minutes we have remaining, this was a very fast, in my opinion, 90 minutes together. You were super engaging. Thank you so much for all of this.
Glad to do it.
If you have any last minute burning questions, ask them now. But Rick, I want to turn it over to you to sum up, and then we'll offer listeners some next steps.
Okay. Summing up, basically my goal today is to get you to rethink, re-examine some of the assumptions you've got about writing as a lawyer, some of the habits you may have fallen into or been drilled into as a writing lawyer, and to understand that given the vast variety of situations many of you meet in your own practice, in your own legal work, that relying on one approach to things is not the most effective way to communicate. And offering a bunch of different tips and strategies and places to look in assessing what your circumstance is at any given time, and making the necessary and available adjustments to make yourself a better writer for the audience you're writing to today, for the task you're trying to achieve today, for the document you're writing today, knowing that tomorrow you may have a different set of circumstances, a different situation, and that you may make other choices. That beyond the sort of basic principles, there are all sorts of adjustments at the margins and adjustments in the little spaces that you don't often think about that can have a major impact in the way you communicate persuasively and be most effective in what you do. So I thank all of you for this. If I can, I have up on the screen here contact if anybody needs to follow up or anything, both my email address, rick@primeprose.com, phone, and a website, primeprose.com. That's PRIMEPROSE. Obviously, if folks are interested in hearing more about these kinds of things in a full day and in-person session, I'd be delighted to hear from you, and we can talk about that too. In the meantime, I hope you will pass the link along to your colleagues and friends who are lawyers and weren't on the site today, and get some of this message out even more broadly. And Alexandra, thank you so much. And I will hold open now for anything else that you've got in terms of follow-up or logistical stuff.
Wonderful. So we do have one last question, and then
Great.
I'd love to share our next step slide with folks.
Okay.
So going back to email, you know, we're in a different world now, obviously. Email is king. What are your suggestions on how to write an email to the other side where the recipient must prepare documents quickly, but you don't want to be obnoxious about it? So again, you need to be persuasive, direct, but
okay.
it all matters when you're trying to get someone to do something.
I think the subject line has to be short and convey the importance, the urgency of a response. I think you can do that without sounding offensive. You can say deadline coming up, but I mean, more specifically, you want to know what the topic is. You know, Jones case, thus and such document, deadline is such and such. I think you want to put in, in as, I think the phrase somebody used in a session I did a couple of weeks ago was the external urgency of the situation, and often that should be the first item in the document. Obviously, if you're writing email, you're not expecting anybody particularly to read past the first or second screen. That's most of what people have found, researchers have found in social media of all sorts. And so it puts a premium on front loading and top loading any information that you think is essential, that it has to be in there very quickly. I would say in this case, both in the subject line and probably in the first sentence or two of the email. I think you can do that. We need to see this by thus and such date. If there's a consequence that they would likewise think is important, laying out the consequence, or else this thing goes forfeit on Monday morning. I think that can be done without in any way sounding offensive about it. But making sure that you're clear that nobody can say, I didn't know you cared, I didn't know it mattered, I didn't know it was important, and that the deadline was coming up in 36 hours. So I would try to convey those essentials as high up in the email as I possibly could, and that would definitely include the subject line. You don't want to just be general Jones case. That's not going to tell anybody anything.
Absolutely.
Does that help? I hope that helps.
Yes, highly agree on the subject line piece. I think that's a great point. So Rick, we've come to the end of our time together today. If you could advance to that next slide for me. Thank you so much for sharing this. I think this was great. I can so easily see how this can be a half or full day session at the bars that you present at. So thank you for that.
Thank you so much. Do you want me to be on during this portion of it, or are you taking the mic down now and you're up? You tell me where you want me to be.
Yep, you can just stand by.
Okay. Thank you, everybody. It's been a pleasure working with you. I hope some of you have been finding this useful and smiling occasionally. All the hands in the air are hard to see from here, but I thank you for the questions that you did raise, and I hope you'll spread the word about this. Thanks so much.
This is the first time we're offering a continuing professional development opportunity for professionals in a specific field. So this is an experiment for us here at the Hyatt Career Center, but we know we have many alumni attorneys, and we want to offer something that would be of value to you beyond our more traditional career webinars. So please fill out our satisfaction survey to share feedback on today's session. I also want to draw your attention to our archived webinars. We have more than 50 of them on a variety of topics. This one will also be posted on the same website on the Alumni and Friends Careers page. We also have a way to connect with one another. So there's the Brandeis Alumni Lawyers Group on LinkedIn. As you heard from the tidbits that our listeners were weighing in with, you are wonderful resources for one another. So please use that platform as a way to connect with one another. Lastly, if you're looking to make a career change, we do have a lot of recovering attorneys, as people have called themselves, who may want to do something else outside of a career in law. Please feel free to make a career counseling appointment with our office. Undergraduate alumni receive free career services for life through the Hyatt Career Center, and that includes one-on-one career advising. And here is my contact information as well. Thank you so much, Rick Horowitz. You are a wonderful presenter.
Well,
and
thank you so
I hope
much.
You all will join me in the Brandeis Alumni Lawyers Group on LinkedIn. Until then, have a great weekend and take care from all of us here at Brandeis.
Bye, everybody.